Yes. Now you can start.
This meeting is being recorded.
1 second. Let me check on the YouTube link. It's perfectly coming up or what? Yeah, it's
Yes.
coming. It's coming up. It's coming up. Only
Now,
thing, your picture is coming something differently,
yeah.
and I am also having some PowerPoint and all those things. Anyway, let us start. Yeah, Pranajji, let us start, sir.
Yeah. Yes, sir. Yes, sir. Am I audible?
Very well.
Am I audible?
Yeah.
Very well.
Yeah. Yeah. Namaskar. Good evening, everybody. I think we are almost 15 members are there. Some people are joining shortly. Welcome all of you to this knowledge sharing seminar of our company PIPPL, Persistent Insolvency Professional Private Limited. Today on Friday, 7th of October 2022, we are having a lecture on our learned speaker, Mr. Advocate Anirudh Suresh, on important Supreme Court legal updates. Sir, let me tell you, we are a company of 127 insolvency professionals all over India. We have got presence everywhere. So we just started in 14 February 2022. Almost 8 months are over, and we are in almost in the operation now. With this, I will request Vinod sir, our founder and promoter, to take the proceeding further and address this August gathering. Vinod sir.
Yeah. Thank you, Pranik. Welcome, Anirudh ji. It is our pleasure that you are with us to deliver whatever the cases listed for today. And Mr. Anirudh ji, advocate, is a corporate lawyer with a core experts in IBC regulatory, appears before NCLT benches across the country. He has admitted numerous Section 9(7) petitions and hold record admission of petitions less than 30 days. He has assisted various successful resolution applicants, including several high-profile matters such as Jet Airways and JP Infra Tech Limited. Further, he is also assisted RP liquidator when end up assistance is required. Anirudh Suresh is a seasoned lawyer and like to appear before the courts. He earlier headed the Delhi office of Badia Legal. And let us welcome Anirudh and it's the time for Anirudh to enlighten us. Over to Anirudh.
Thank you, sir. Thank you for the warm introduction. So we have briefly, made note of couple of Supreme Court judgments, which are landmark judgments, and how IBC has evolved. Why all these judgments I'll be, explaining briefly, probably 5-10 minutes or so. But each and every judgment would be very important for the reason being, insolvency and bankruptcy code is only from 2016 onwards, right? Like how we generally know the CPC or the CRPC, which are all from 1800 or 1900, it is well established and everybody knows the position of law. Whereas in IBC, what happens? It's a new legislation, and lots of gray area was there, and lots of ambiguity was there in several places. So therefore, what Supreme Court did when it decided on this position of law, it not only decided on the question of law, but it also gave a very, very good commentary. Each and every judgment of this SR Steel or Swiss Ribbon and, these Mobilox and all these innovative and all these judgments, each judgment is 100 to 150 pages. They could have given the judgment in 20 pages and closed on the particular facts of the case, but it went a step ahead and, explained everything in detail as to why this act is written like this, why this regulation is written like this, why this section is written after this section. Proper and thorough understanding of IBC and the regulations were given by the Supreme Court in these landmark judgments. So one such judgment is, I'm going to start off with one such judgment, which is, COC of SR Steel India Limited versus Satish Kumar Gupta, which was decided by Supreme Court. So in this, what happened was, earlier in the case of Mobilox and Innovative, both decided by the Supreme Court itself, lots of ambiguity was there with respect to the position of operational creditor and the financial creditor. People are always saying, why are there secured creditors? Why are they not unsecured creditors? Why he's getting more or why am I getting less? these kind of struggles are always there between the operational creditor and the financial creditor. And the twist, what happened in this case, the particular twist was when this matter was decided by the appellate tribunal in during the appeal, they said that operational creditor will have the same rights as the financial creditor with respect to the payments of dues. So that is where the entire thing was set haywire. I think somebody has to, yeah. So when this question was then later on given to Supreme Court, then Supreme Court obviously had to set aside the NCLAT ruling based on the provision that when see what it's a simple logic given was, now let's assume I'm a financial creditor and my claim is, let's assume 100 rupees. So when my claim is 100 rupees, I would have actually given you 100 rupees, right? Actually 100 rupees in money would have been given, and it's a secured credit based on whatever pledge or whatever property, whatever collateral taken by the bank. They have given you 100 rupees in full. Whereas in the case of operational creditor, what happens now? Let's assume I am in service-based industry. Now they might have actually invested or a manufacturing plant also. Let's assume their actual capital investment may have been 10 rupees. Now let's assume he's selling you a biscuit packet which is rupees 100. His actual investment in that biscuit packet may be 10 rupees, but he is selling it at 100 rupees. And now that you have not paid him 100 rupees, his claim will be 100 rupees. So the operation creditor, even though his claim is 100 rupees, his actual investment or actual capital will be somewhere around 10 rupees or 15 or 20, whatever it may be. Whereas the financial creditor who is giving, its claim is 100 rupees, means he has given you 100 rupees, right? And that 100 rupees also what he's giving is, again, he has taken it from the public. It's a public money which is invested in the banks. And therefore, the time value of money should be considered. And therefore, interest is also going to come along with the claim amount. So based on these logics and this reasoning, they have differentiated secured creditors and unsecured creditors. So this matter was settled earlier also by Supreme Court, but surprisingly, NCLAT said that OC and FC are one and the same. So that is why again Supreme Court had to deal with this issue in detail and give a clarification and again reiterate on its earlier judgments and say that that is not the case. OC is not the same as FC. It is only with respect to the payment, that the payment being made to the operation creditors, they will get a priority. But with respect to the claim and amounts and things like that, it is obviously the financial creditor, being the secured creditor, who is going to get priority or who is going to get more in terms of the resolution plan. So this is one part of the SR Steel judgment. Now I would like to go to the next one. Next case was in the case again which was decided by Supreme Court. In this case was Municipal Corporation of Greater Mumbai versus Abhilash Lal. So again, this case, what has happened again, this was during the advent of IBC only back in 2016. It was still in a young process. Nobody knew what happens after CRP is admitted. After moratorium starts, how exactly it happens. No plan was approved as of then. 16 the act came in. Probably petition started, getting admitted in 16 onwards, and some plan being admitted was only happening at the end of 2017 or 2018 ending. And this was one such, early issue that was faced by NCLT, you can say, wherein NCLT had to decide upon Section 238 of IBC. Now, Section 238 of IBC gives an overriding effect over any and every law in the country. That is what makes IBC powerful, so that it can control and bring about anything and everything under the ambit of IBC. Now, that using the Section 238 provision, the one mistake, now we'll come to the facts of this case. So in this case, what happened? Municipal Corporation of Mumbai, like they have granted a land to a particular person by way of an agreement, saying that he will construct an hospital in a particular time frame. And once that hospital is constructed, after that only there will be a lease deed being executed, and then only the land will be completely granted to that company who builds this hospital. Now, this company who is building this hospital, is unable to pay his dues, and he is subsequently declared as bankrupt by NCLT. And the plan is filed, when a resolution plan is being filed in this matter, they totally ignore the right of the Municipal Corporation of Mumbai. even though the land itself was still, the land owner was still the municipal corporation, whereas as per this plan, they would say he can take over the land, he can take over the premises, he will build all these things, and it is totally going to ignore the rights of the municipal corporation. And when he challenged this in the appeal, and again appellate tribunal was wrong by saying that section 238 of IBC is there, it will override anything and everything, so therefore we cannot interfere with the order. Now, Supreme Court, then this question was then came before Supreme Court, wherein then the Supreme Court clearly said that, of course, 238 is there, and of course, moratorium is there in place, but moratorium can affect only the assets of the corporate debtor. And in this case, since the land was not at all the asset of the corporate debtor, you cannot, totally ignore the right of the Municipal Corporation of Mumbai. And therefore, that is how the Supreme Court interpreted Section 238, saying that all that overriding powers given and all the other things can happen only if it is on the assets of the corporate debtor, not on any other asset which is not owned by the corporate debtor. So this is one landmark judgment by them in 2019. Next, I can come on to another judgment. Now, this is in the matter of Gyansham Mishra and Sons Private Limited versus Edelweiss Asset Reconstruction Company, which was decided by the Supreme Court of India on 13th April 2021. Now, here the question that was put before the Supreme Court was that, now you must be aware, you are all being resolution professionals. I'm sure you have got lots of problems like this, wherein the statutory dues, let it be the income tax or the GST or these kind of claims, these departments, always fail to file a particular claim before you within the stipulated time frame. And so as of which, what happens was, their claim was not being admitted, or, their claim was not even received. And then the plan would be approved. After the plan being approved, we always know what is the intention of a plan being approved. When the resolution plan is approved, whoever is buying it is always going to buy it in a new slate. Now, once he buys a company in a new slate, you cannot have a GST department or income tax department, then harassing you for your prior claims and prior things like that. So this issue was resolved by Supreme Court, saying that all the dues, including the statutory dues owed to the central government or any state government or any local authority, if it is not part of the resolution plan, they will stand extinguished. Right. So it is the duty of these governments or these authorities to file their appropriate claims within the time period. And if it is not there in the resolution plan, and that's it, the resolution applicant is going to get a clean sheet and he can continue. No further harassment can be done by these government authorities or any local authority with respect to the dues of the corporate debtor before the approval of the resolution plan. This was the third judgment. Now I'm moving on to the fourth judgment, which is the matter of Lalit Kumar Jain versus Union of India. Now, this was decided by the Supreme Court again in the year 2021. I just want to give a pause here. Now, in the last three judgments that I have discussed, does anybody have any query or, want any further doubts, or please feel free to ask. All right, so I'll take it as there's no doubt. So now I'm moving to this fourth one, which is Lalit Kumar Jain. So here what happened, as you're all aware, back in 2019, insolvency was a big concept and government enacted or enforced part by part. So even the personal guarantor and all those things were not enacted initially. Only in 2019, they enforced this provision against, where you can initiate CRP proceedings against the personal guarantors. So when this happened, now when the IBC, when the definition of the code, they say that the provisions of this code shall apply to, and I'm just reading out the relevant section itself. Subclause A says any company incorporated under the Companies Act. B says any company governed by any special act. C, any limited liability partnership, LLP. Then D is any such body incorporated under any law as the central government may deem fit. Then E, personal guarantors. F is partnership firms. And last is individuals. Now, the code is applicable to these many categories of people, but as far as section 7, 9 or 10, initiation of CRP being concerned, it was only applicable under companies. Any company incorporated under the Companies Act. All the other provisions, they were not enforced. That is why we are not filing any CRP petitions against an LLP or an individual or a partnership firm for that reason. But now when they had to enact this personal guarantor, when they wanted to enforce the sections 95 to 100 and all these sections which was dealing with personal guarantors, they enforced all these provisions, but only with respect to personal guarantors, right? They said it's not going to be applicable for section 7, 9 or 10. These provisions of the code will be only applying insofar as it relates to personal guarantors. That is how the government notification came out. And when this notification came out, it was, directly, now there are lots of thousands of personal guarantors all over the country, crores of them are there. And everybody were aggrieved by it, that they're saying that, till date, they were only against the corporate debtors, only the company, and these personal guarantors were sitting silently and nothing much was happening before DRT. So they wanted to, they have everybody before every high court has challenged this notification saying that, the government doesn't have a power to notify only certain aspects of a provision and not certain aspects. They cannot notify what they want and, partial and impartial and these kind of things. Lots of high court matters, lots of writ petitions were filed in all sorts of high courts throughout the state, throughout the country. So what Supreme Court did was, it automatically said that all these matters pending before every high court with respect to this notification shall be transferred to the Supreme Court, and Supreme Court will decide on this question of law. And Supreme Court ultimately held that the government has the powers to do this as per section 239 and other provisions in the IBC itself. They have every power to invoke whichever provision they want and invoke whichever the provision they do not want. And ultimately, it upheld the notification passed by the government of India. And therefore, since then till now, as you're all aware, any petition against personal guarantors and everything, they're all running, no issue. So that was the fourth judgment on personal guarantors. Now the fifth judgment is by the Supreme Court in the matter of Anjali Rathi versus Today Homes. This was decided on 8th September 2021. In the meanwhile, anybody has any doubt in the previous judgment, please feel free to ask. Yeah. So now in this fifth judgment, now here another issue which was decided was, now, after CRP being initiated, there is going to be moratorium against the corporate debtor. But now in this case, the fact what had happened was, even before the CRP was initiated, this was a case of home buyers against the developers. So when the home buyers claims, was not satisfied, there was a settlement agreement between these home buyers and the directors of the company, saying that, we will honor the terms and, we'll make the settlement and things like that. So later on, when CRP was admitted against the company, against the corporate debtor, now the question was whether the moratorium is also going to protect the directors, because the settlement agreement was signed by the directors. And Supreme Court held that the petitioners would not be prevented by the moratorium under Section 14, because, a promoter there would be an individual, and this Section 14 moratorium only applies to the corporate debtor. And it also granted liberty to the petitioner to take remedies as per law and, file necessary claims and get necessary amounts recovered against, so that it can take action against the directors. So this is what about the fifth judgment of Anjali Rathi, that to sum up, that the moratorium will not be applicable against the director or the promoters. It is only against the corporate debtor and assets of the corporate debtor. Now I'm moving on to the sixth judgment, which is EBIC Singapore Private Limited versus COC of Educom Solutions Limited. This was also decided in 13 September 2021 by Supreme Court of India. Now here, what issue was, now till date, all the plans were being submitted, it was being approved, and all these issues were settled by Supreme Court. This was the first time a matter was there wherein, a resolution applicant, after the approval of the resolution plan by the NCLT, he wanted to withdraw. He wanted to, he's not going further, probably. He has paid the EOI money, has paid the earnest deposit and things like that. But he's not ready to make the further payments as per the resolution plan. And, he's seeking to withdraw the very resolution plan itself. And there what happened, there is no specific law, or there is no specific section, nothing is written in IBC on this point. So NCLT and after NCLAT, when it went to Supreme Court, instead of going into, so much of merits and so many other different sections and different interpretations given by the parties in NCLT and NCLAT, Supreme Court simply said the point that, since IBC is silent, whether a resolution applicant can withdraw with the resolution plan, they said that there is no provision, there is IBC talks about everything else, like, how the CRP starts, how you are going to give an expression of how the expression of interest is going to be given, how the step-by-step process, anything and everything, the entire process is there in the legislation. And for the simple fact that, there is no process, or there is no mechanism, or there is no wording in the legislature, or how a plan can be withdrawn, that itself shows that, the legislation has no intention to allow the resolution applicant to withdraw the resolution plan. Therefore, the Supreme Court said you are going to be bound by the resolution plan. You have to satisfy, you have to go ahead as per the terms of the resolution plan. There is no question of withdrawal. This is the 6th judgment of EBIC Singapore. Now, all these 6 judgments were actually given to me by your committee of Mr. KJ Vinod. So I hope I have answered, and I hope I have discussed these 6 judgments. Apart from this, I have several more. But before moving to those judgments, I just wanted to pause and ask anyone, anything so far, any feedback, any comments or anything.
Yeah, thank you, Anirudh sir. Well done. And see, in a clipsy manner, you have explained everything in a nutshell to the people. Here, while we discussing, we were talking about the interest component to the operational creditor.
Yeah.
It will be nice if you could take it, and then at the end, we will take up the questions.
Oh, sure, sir. That works for me. So now, all right, sir. So
Thank
now
you.
what happens, like I'll give you some big background in this, like earlier how I explained the difference between secured creditor and unsecured creditor. And since, the financial creditor has given money, there is actually time value of money, therefore he's getting interest. Now, nowhere in the code, it says that the operational creditor cannot claim interest, right? We have always been claiming interest as operational creditors based on agreement or contract or whatever provision as per law. But recently, what happened earlier this year in 2022 January, one of the NCLT benches of Delhi, NCLT Court Hall number 4, went on to the extent of saying that there is nothing written in the act or nothing written in the code which allows an operational creditor to claim interest. Only when it talks about financial creditor, when in the definition only for financial debt, the definition of financial debt includes interest, and operational debt, it doesn't include interest. Therefore, the operational creditor cannot claim interest. This was totally against anything and everything that had happened till date, because there were several Supreme Court judgments on the point earlier, even by NCLAT also earlier, saying that if there is any contract, if there is any agreement, if there is any provision between the parties which allows them to claim interest, they can claim interest. That was what was there in the couple of judgments by Supreme Court and Appellate Tribunal also. But NCLT bench said this, which was totally contrary to this. And I mean, you're all RPs, you would have all seen the claim forms. Anybody is giving you a claim form in CRP process, or anybody is giving you a proof of claim in liquidation also. The form itself contains, when it is an operation creditor who is giving you a claim form, the form itself contains 3 ingredients, saying that total, it says principal amount, interest amount, and then it says total amount. No, the form itself given by IBBI, the form itself given by the legislature is giving you 3 breakups, asking you the principal amount, interest amount, and the final amount. Then how can the NCLT bench say that, interest cannot be claimed? So this issue was, obviously going to get overruled very soon. And along with this issue, another issue what NCLT did was now, claim from 1 lakh, it became 1 crore. No, the threshold to file an application became from 1 lakh to 1 crore. And in this facts of the case, which NCLT bench was deciding, the claim was somewhere around 96 lakhs, the principal amount. Then along with interest, he had claimed 1 crore. So basically, along with interest, he had reached the threshold amount of 1 crore. Now, what NCLT surprisingly did was saying that since interest only cannot claim, you cannot claim interest, then there is no threshold limit of 1 crore also. Therefore, this petition is dismissed. Now, very recently, in the matter of, let me just read that matter's name, just a minute. In the matter of Prashant Agarwal versus Vikash, which was decided by appellate tribunal. Let me just give you the exact date. Yeah, it was decided by the appellate tribunal on I apologize. Yeah, it was decided on 17 July 2022. So the appellate tribunal rightly said that earlier appellate tribunal judgments or earlier Supreme Court judgments have clearly said that the OC can claim interest if there is any clause or anything to that effect. Therefore, this NCLT bench decision of Delhi has to be set aside, and they give a explanation of operational debt, and they give the ingredients of operational debt, and they say that interest can be claimed by the operation creditor. So therefore, any operation creditor, as per the Interest Act, then there is Sale of Goods Act. Even though there is no clause in the invoice, we usually advise our clients that you are making an invoice, you please put a clause of interest saying that if you don't make the payment with so and so days, interest at the rate of so and so will be charged. So some such provision should be there. Even though if such provision is not there, you can always rely on Sale of Goods Act and the Interest Act, because once you're providing goods and services, and if there is a delayed payment, you always have a right to claim interest. And since NCLAT has also told that operation creditor can claim interest, you can, operation creditors have every right to claim interest. And now I'm moving to the next judgment, which was again decided. Now this judgment was decided by Supreme Court by again Honorable Justice Nariman. It's a matter of P. Mohan Raj and others was the Shah Brothers Ispat. This was decided in 1st March 2021. Now, why this judgment was almost around 150 pages judgment when it came out? Why this judgment is important is, lots of times what happens, there's always a check. Let's assume a check is given by the corporate debtor, and the check is always going to be signed by the director or someone. So the initial judgment before this, whatever position was there was saying that when moratorium is imposed, we read section 14 of IBC along with section 238 of IBC. So when you do that, moratorium will be imposed and no proceeding can happen in any court against anyone for anything. So as a result of which, all these check bounce cases was not being pursued once the CRP was running. But now Supreme Court in this matter went into length about this issue, saying that the check which has been issued, it is actually signed by one of the director or the authorized representative of the company. Therefore, when you read Negotiable Instrument Act, Section 141, it is not only the company, right? Even the person who is responsible for management of the company is also going to be, is also an accused as per the Negotiable Instrument Act. So therefore, that person who has signed in his individual capacity or as a director or a proprietor or a partner, whatever it may be, he cannot take the protection of moratorium in IBC. So this judgment gives a brief explanation or, relies on lots of earlier judgments and gives a very good rationale, saying that since it is in his personal capacity, the moratorium read with section 238 will not apply to the check bounce cases. So therefore, people who have given these checks as a director or whatever it may be, the applicant or the operation creditor or the financial creditor, whomever it may be, they can pursue against them under the Negotiable Instrument Act, as well as against the company in the NCLT. Multiple proceedings can happen. There is no loss in happening for the multiple proceedings. So this clarification was given by the Supreme Court. And another judgment I can take now is with respect to rent. Now, you must all be aware, or you must be having several confusions in this aspect, because back in 2020, several NCLT judgments were passed. Some NCLT judgments were saying rent is operational debt, lease is operational debt, you can claim it. Back then 1 lakh was the threshold limit, right? So somebody is not paying rent, we used to file an CRP application in NCLT saying that he's not giving me rent, declare him bankrupt. And appeals were being faced in appellate tribunal, and appellate tribunal surprisingly passed divergent views, right? In August 2019, appellate tribunal said rent is not operational debt. They gave clarity on, they relied on several committee reports, several other documents, several these things. They said rent or lease cannot be operational debt. And the member who were passed a judgment retired, and subsequently the next month, the same NCLAT says that rent is operational debt. Now, this was a fix. Nobody knew what to do. Now, appellate tribunal is saying rent is operational debt. Next month only it's saying rent is not operational debt. What to do? There are several matters pending before several NCLTs. And what will NCLT also decide? The NCLT is also stuck as to how to decide what to do, because appellate tribunal has to decide the issue. And this matter was then appealed in the Supreme Court. And sadly, from 1.5 years or almost 2 years now, Supreme Court has not taken up this matter, or Supreme Court has not decided this issue. And since this problem was created by NCLAT, what NCLAT did was, in this matter of, let me just tell you the name, in the matter of Jaipur Trade Expo Center Private Limited versus Metro Jet Airways Training Private Limited. This was again appealed from NCLT Jaipur matter. So NCLAT formed a larger bench. Now, all these earlier judgments formed by the appellate tribunal was by 3 members, 2 members, like so on. So NCLAT formed a larger bench of 5 members. So 5 members sat and decided this issue, and they once and for all decided that rent or lease is operational debt. So this is the current position of law. Therefore, anybody not paying rent or lease, whatever it is, parties can initiate CRP proceedings. And even the claims which the RPs or liquidators will be getting can entertain them as an operational creditor. Because until then, the position was it's not. This was a very recent judgment passed in, let me just give you the exact date, was passed in 5th July 2022. It's a very recent judgment passed by the appellate tribunal. Yes, sir. So, yes, sir. I think I'm done on at least 9 judgments so far. Any doubts, any questions to make it an interactive session?
Yes, sir. When I was giving the list, I didn't mean that you will be closing it within this shorter span of time. I wondered, and you did it perfectly. Over to the member for any interaction. Anirudh is so much interactive person, and he's one of the advisory board member in our company, and it is better you can have any question related to the legal updates or any confusion of law. Welcome to the member for the interactive session.
I think everybody is on mute. Yeah.
Sir, I have a question.
Yeah.
Sir, regarding this CRP,
yeah,
IRP or RP, they have whether they can claim interest, sir, for that expenses and fees that they have not paid for about more than 10 months.
On the fees paid to the resolution professional, is it?
Yes, sir. Yes, RP as well as IRP. Both these will come to about some few lakhs. So whether they are eligible for getting the interest, sir, because the invoice raised by the RP specifically says that if the amount is not paid within 30 days, it will carry 2% interest per annum.
Yes, sir. So like I said, then it is an operational debt now, because IRP is also providing a service only end of the day.
Yes, sir.
and service will come under operational debt.
Yes.
And since it is an operational debt, you can use this enclad judgment. You can show your invoice, and there are earlier enclad judgments also saying that you can claim interest if it is written on the invoice, or if it is there is a contract, or if there is an agreement and things like that. And IRP then in that case will have every claim, will have every right to claim it along with interest.
In fact, what happened was that the amount that is paid to the lawyers as well as other expenses, video conferencing, everything, it was spent by the IRP from his own deposit withdrawal, by withdrawing his deposit amount from some other bankers, personal savings.
Yes, yes.
There is a real case for getting the interest. This is a real situation, sir.
Got it, sir. So by all means, you should use that latest enclad judgment and claim the interest.
Is there any specific citation, sir?
Pardon, sir.
So is there any specific citation for eligibility of getting interest by the IRP or RP?
So there is no particular judgment saying interest by IRP or RP. They've said interest can be claimed by the operational creditor.
Right.
Now, yeah. So since it will fall under operational debt only, no, sir, because since you are giving a service, it will fall under operational debt only. You can rely on the same judgment. It is going to be applicable for the RP as well.
The particular case, there was the CRP lasted for more than 10 months. So that time, there was an appeal, there was a withdrawal petition, it was ultimately decided after 11 months only. So this amount was not paid. This is the thing.
Got it. So application has to be filed before NCLT. If I'm sure they'll direct them to pay the fees immediately. Yeah.
Right, sir. Thank you.
Yeah. Thank you. If nobody else is having any doubts, sir, I'll take it that I have done a good job. That I've explained everything properly. That nobody is having any doubt means I'm glad on that point.
We don't get always Anirudh ji. It's a free time. Maybe some time is available. Who time is available?
Yes.
It's not possible to get Anirudh ji always. He's the busiest person having cases across the country. Anirudh ji, I am having few things to discuss with you out of scope.
Please.
See, the new amendment, it is making IPE to take the possession of IP. And there is no governing law specifically made for IPE as an IP. Well, we believe that, okay, when they are taking the possession of IP, the governing law of IP will be applicable. But the problem, why IBBI is allowed IPE to take the cases in his name, because of the infrastructure arrangement what an IP is having.
Yes.
My core question is this. What is infrastructure and where it is defined? 1 minute, sir, don't laugh. Okay. Is it that the simply paying 1 crore rupees net worth is sufficient? Is it that the infrastructure? You see, infrastructure should be defined. Yes. Otherwise, you and me can create an IPE simply by investing 1 crore rupees. Does it mean that after simply become an IPE, I'm having the required infrastructure to handle 10,000 plus case, 10,000 crore plus cases? How do we test it that this IPE is having the capabilities of the infrastructure? My dear sir, today 2 persons can join an IPE.
Yes.
Does it mean that he is having all the infrastructure? This is my question. Infrastructure is my question. Correct. Suppose if he is taken 5 cases in his name, I mean IP's name, and the infrastructure is sufficient to mitigate all the cases, I don't know. Correct. So across the country, if you see except few IPE, there are many IPs, 180 or something like that. It is likely to go maybe 500 IPE coming for. Okay. But where is the definition of infrastructure? Or it is expected or what?
Yes.
This is the first question. It is not from the legal angle, but in a general.
Yeah, got it. Got it.
How do you think it will? How do you look into this?
So basically, again, so these are all the gray areas that we're talking about since it's a new legislation. So what the legislation would have actually intended or, would have in its mind is, it's not a one-man army. When you're talking about a RP in a particular IP, that, it is a one-man army. So since he's one person, he'll have his own limitations. Whereas if there is an office, if there are staff along with him, if he has a team along with him, if it is more than, if he has a team, it's always better than one person. No? So it's just to differentiate between that one-man army and, having a proper team and, all these things is the logic behind infrastructure is what we can assume.
Absolutely, I do agree. A one-man army cannot do anything in IBC. He should have a very good chain relations and net worth across the country. I do agree, sir.
Yeah.
But where it is stipulated for IPE,
Yes.
it is not stipulated. For example, myself and Mr. Parsoya, he is in Rajasthan, I am in Tamil Nadu. We can simply invest 1 crore rupees and say we are IPE. The problem why I looking into, when everybody filing EOI with the financial creditor, they will take it for the tabulation. They will have their internal tabulation system. So based on that, even though myself and Parsoya is incorporated an IPE, we will never end up with the top ranking to get the assignment.
Yes.
Right, na? Because when they ask so many parameters, how many these things you are completed, resolution you are completed successfully, how many liquidation put it, double the value of the things. My dear, myself and the person may not be having that beauty of cases. But what is the presumption is going to the mind of the people that if I become IPE, then I got everything. That is what I thought I will just discuss with you since you are in the IBC stream. You may not be having a specific solution for that, but at least.
So, but a small solution I can give advice on this part is you can file an RTI before IBBA and ask them these questions.
Exactly, this is the intention I would like to take you because
Yes.
I am planning to do a session maybe after next week.
Yes.
Challenges of IPE, challenges of IPs. I am in the system for the last 3 years. My thumb is challenges of IP. That reason we are incorporated this company.
Yes.
Now we are 127 IPs across the country, strongly build up this platform.
Yes.
And 127 IPs are having 127 officers and their own staffs. You see the huge infrastructure what we are having.
Yes.
But we are not an IPE. Doesn't mean that we are not qualified to take the cases. See,
Yes.
ultimately, this is what correct, na?
Yes.
We are having advocate like you, heavyweight advocates, correct? And we are having people in the advisory board who handled more than 2,000 cases. Sorry, 2,000 plus cases monitored, correct? Are we not a qualified infrastructure? If the question of the IBBI is the infrastructure, then this is what it is very important and pertinent, which I would like to share with you, sir. And the legal angle, I'm also talking to other advocates about this. Because without defining something, you are telling that they are the best and bestest people. How it is possible? Is it a question on the IP? We just like us, correct? No? We are
Yes,
having such a platform and we are not recognized because we are not invested 1 crore rupees. We can invest 1 crore rupees. That's not a problem. If we contribute 1 lakh each, it less than 1 lakh each, we will be an IPE. But the problem is not ending with that. Anyway, as you directed, and I will discuss you this thing in private also.
Sure, sure.
I think I am taking more time. I'm not giving time to members for any specific question. Sorry, over to the members.
I have a question, Mr. Suresh.
Yes.
Can you repeat the judgment in case of the filing of case under a Negotiable Instrument Act, the check bouncing. What was the case in Supreme Court?
Yes, sir. It is P. Mohan Raj and others versus Shah Brothers Ispat Private Limited.
P. Mohan Raj and others.
Yes, sir. And what I'll do is I'll just text the Manupatra citation in the chat box.
Okay. When was this judgment delivered?
1st March 2021.
21.
Yes. Sir.
So in case a director has issued a check with the company's stamp,
yeah,
he is liable to be prosecuted.
Yes, sir, he is. Even though the CRP is going against the corporate debtor, this Negotiable Instrument Act can continue against the director.
So all the directors or the director who has signed?
No, only the director who has signed. Only the directors who have signed.
So if the director who has signed is no more, then the other directors are not liable to be prosecuted.
Then somebody has to step into the shoe. Then if the director is but at the time of presentation of the check, was he the director?
No. Yes, he was a director, but he has passed away.
So he's passed away. Then his legal heirs should step into his shoes, no, sir? Because he will have a family. His legal heirs will step into his shoes.
So they will be liable to be prosecuted?
Yes.
Criminal offense can also be passed on, is it? Only the civil liability is passed on to the legal heirs.
Yeah, but what happens in this check bounce case? It's a mixture of this thing, no? So, but you can have to look into that either ways. But as of IBC is concerned, I'm saying you can go against the director in this one. Now, this person has been passed away. That we need to look into that.
In a recent judgment by the High Court, in case of Prenet, the High Court judge has delivered the judgment saying that the Negotiable Instrument Act will not hold good, and there is no criminal case against the director who has signed in his individual capacity. In case of a personal insolvency case, the director in his individual capacity had issued a check, and the High Court held that he is not liable to be prosecuted under the Negotiable Instrument Act.
No, I think so. The facts will be different. So we'll have to look into the facts of the case also. Because if he has issued a personal check, means he is going to be liable. As long as there is a debt, legally enforceable debt, he has to be liable for that.
No, but since there was a moratorium under the personal insolvency, he was not liable to be prosecuted. That is what
therefore, then this Supreme Court judgment has to be given to them, sir, in that case, because this is also a fairly new judgment, wherein it says that moratorium will be applicable only on the corporate debtor, not on the directors. And the check bounce cases can continue.
But you said the Supreme Court judgment was delivered in 2021.
Yeah.
And this High Court judgment was delivered only last month.
So probably they are not aware of this judgment, no? Because High Court cannot overrule a Supreme Court judgment, no?
That is what I'm saying, that how come then the High Court...
So the High Court is not aware, or the advocate who is defending that matter is not aware. If either of them had been aware, then this would not have happened.
Okay.
Yeah. So you can always file a review before the same High Court. You can file a review and you can show them the Supreme Court judgment. They will review their own order.
Thank you.
Yeah. Yes. I think somebody is raising the hand. Mr. Basant Pandey, yes.
Mr. Vasant, have you any question?
No.
I think the hand was accidentally raised.
Yeah.
Mr. Basant Pandey, you have any specific question? Mr. Basant Pandey? Okay. Basant Babet, so many times, hands up, thumbs up. Okay, fine. What do you think? We will conclude, members. Sethji, how do you think? We'll close it?
Yes, sir. I think.
Yeah. Yeah, thank you for the nice session, sir. You have delivered. And this is the first session you are with us. and we could interact with you well. And you are very simply stated and explained everything. Mr. Sethi, can you come forward and bind up the meeting, Sethi?
Yes, sir. Sure.
Thank you.
Yeah. So today we have with us Mr. Anirudh Suresh Kumar, our panel of one of the member of our advisory board panel. He is a very learned speaker, and he has done very good cases of IBC, Supreme Court as well as Tribunal, and helped many insolvency professionals in insolvency resolution process. Today he has given, in a very short span of time, he has given almost 9 uh, Supreme Court and MCLAT cases judgments, and I hope that members are enlightened with the knowledge shared by Mr. Anirudh. And he has very good knowledge in IBC and these judgments, and in a very short span he has explained everything. Very interesting judgments he has shared. Maybe it is check bouncing cases or government dues matters, rent matters, interest matters. These things are seldom known to the members uh, while we are studying the Bear Act. So by this, we have very good knowledge by your this session. So we thank you very much to you, and hope that you will continue to support us in the coming time by giving your knowledge to our members. And I thank you so much from on behalf of all the members of PIPPL and other insolvency professionals and bankers who have joined our webinar. And I also thank you to all the PIPPL members and the insolvency professional and bankers who have joined today's webinar. And with these words, I once again thank you and close this session. Thank you so much.
Thank you, sir. Thank you for having me, sir. Thank you for the invite.
Thank you.
Yeah.
Always feel free to let me know if you need anything. Anyhow, you can always contact me. I've shared my contact details. Looking forward to having another discussion with you all in some other meeting someday. See you. See you.
Yeah. We have a very I think we left out. Okay. Thank you, members.